Hi everybody, thanks for watching. This is a slideshow video on a common issue. What happens when your lease is rejected in bankruptcy court? If your lease is assumed, the debtor has to cure the default, what it owes on the lease, and has to stay current. It may have to give some kind of adequate assurance that it's going to stay current. But if your lease is rejected, you're going to get you're going to have a damage claim, and the question is how much? Again, pursuant to the disclaimer, this is not legal advice on your particular case. This is like reading a book, just general advice. So I'm not your lawyer unless I'm retained by you in writing. Okay, 365, that's the code section that governs this issue. And the question is, if a lease is rejected, first it has to be unexpired for this section to apply. If it is unexpired, and it is rejected, then what are your damages? 502b6 controls this issue, and it sets a cap on damages. Normally, your damages would be breach of contract, but here there's a cap, and the cap is very specific, but lawyers have found a way to make it confusing and argue about it. So we're going to go into some of the issues that have been raised. Okay, the first case we're going to talk about is Fellini's Basement, 2015, Delaware, a bankruptcy court level. Okay, so everybody knows, or a lot of people know, Filene's Basement operated retail clothing stores, discount stores. They took over a lease and renewed the lease, and then unfortunately 2011 they filed bankruptcy and rejected the lease pursuant to 365. So they're gone. Question is, what does the what is the claim of the landlord? How much is the landlord owed here? So the landlord filed a claim pursuant to 502b6 and also two additional claims. Landlord had to fix up the premises. It wasn't broom clean. Had to remove fixtures and whatnot. Also, there was a mechanics lien that was placed. The creditor of Filene's Basement placed a mechanics lien. Had to get rid of that. So landlord wants to be compensated. So the big question is, and we'll go over the statute in a second, what is the 15% referred to, and the two additional claims, are those capped by 502b6 or are they not capped? Are they just separate claims? Okay, 502b6, the rent reserved by such lease without accelerate. This is the damage capping statute. So I'm actually going to read the whole thing. Provides that a claim would be disallowed to the extent that if such claim is the claim of a lessor for damages resulting from the termination of a lease of real property, such claim exceeds. Okay, so in my opinion, the structure is a little bit ass backwards, but at any rate, if anything exceeds this amount, then it's void and disallowed. So by by reverse psychology or backwards thinking, anything that doesn't exceed this claim is good. Anyway, A, the rent reserved, if such claim exceeds the rent reserved by such lease without acceleration for the greater of 1 year or 15%, not to exceed 3 years of the remaining term of such lease, following the earlier of the date of the filing of petition and the date in which such lease a lessor repossessed or the lessee surrendered the lease property, plus any unpaid due under such lease without acceleration on the earlier of such dates. Okay, so we're going to focus here on the first part, 502b6a. Can't be greater than the rent reserved by such lease without acceleration for the greater of 1 year or 15%, not to exceed 3 years of the remaining term of the lease. So So what does the 15% refer to? Does it refer to 15% of the total rent that's owed until the end of the lease? Does it refer to 15% of the time that's left on the lease? It's confusing. So let's find out. Well, the landlord argued that the damages are capped based on whatever rent was due left over on the lease multiplied by 15%. 15% of the total rent left over. Excuse me. Filene's Basement argued that no, it's not the rent. It's 15% of the remaining time left on the lease, and it can't exceed that. The landlord also asserted that it's abandonment, the cleanup issue, and the mechanics lien shouldn't be capped. Not covered here. Of course, the debtor said, well, it should be capped. The bankruptcy court basically exercised its interpretation of the statute and decided that the statute refers to time, not rents. So this is again the two arguments. And this is the landlord argument is known as the rent approach, which some courts adapt, and this court noted that the courts differ on this issue. So there's a conflict among the courts. This is called the landlord's version that he's asserting is called the rent version. Filene's Basement, the debtor version, is called the time version. Of course, the time version always ends up being a smaller amount than the rent version. Well, the bankruptcy court it was a statutory construction issue and decided based on its interpretation, like I said before, the 50% refers to time. The court also looked at the issue of the additional damages claim and decided that if the additional damage claim arose from the lease, because of the lease, due to the lease, then it's capped. If not, it's not capped. So the court looked at the broom clean issue and decided this was just part of the breach of the lease by the debtor. And so it's part of the lease, controlled by the lease, and is capped pursuant to 502b6 because any claim related to the breach of the lease is capped. But the court noted that the mechanics lien claim, that's a whole different claim, not related to the lease, not based on the lease. It's not a breach of the lease, and it's existed independently of the lease. So that claim is not capped. So you have to take a look at what's the conclusion. Takeaway is you got to take a look at where you are, where the court is, what the rulings have been, to figure out the claim that's going to probably be allowed unless you want to litigate it to a higher court, or maybe the court has not rendered an opinion on this particular issue, but it pays to find out. And if you're going to be compensated on 50% of the time remaining or 15% of the rent remaining. And of course, if you have additional causes of action or additional claims that you want to make, this gives you some kind of guidance as to whether it's going to be capped or not capped. Of course, lawyers are going to argue about anything, but this gives you some kind of guidance. Just for the sake of clarity, we did this slide under the time approach. The landlord, just to be perfectly clear of what this means, under the time approach, the landlord's capped rent would be obtained by multiplying 85 months, and that was what was left over, by 15%, and you get 12.75 months, and then you multiply that by the rent, and you get that number, $1,845,524.25. Under the rent approach, the The landlord's cap damage should be calculated by totaling the amount of lease of the base rent remaining due under the lease and multiplying that by 15%. Of course, you get a bigger number, but in this case, landlord loses and is capped at the smaller number. Well, this is another court that faced pretty much the exact same issue as the last one. This one's in California. It's the District Court, Ninth Circuit, 2011. I'm going to go through this pretty fast because it's exactly the same, basically. The issue is, the landlord leased office space to the debtor, Heller Elman. Heller Elman filed for bankruptcy, rejected the lease, and the question is, what are the damages? The landlord, again, wanted to use the rent calculation, and the debtor argued that it should be 15% of time, not 15% of rent. As you can tell, there's a big difference. 13 and change versus 15 and change. Okay, so we know that positions. The bankruptcy court held that that the landlord was correct, the rent applied, and on appeal, the district court reversed. This is the statute. Basically, it's the same thing. The district court's looking at the statute and looking at the language and making an interpretation. Like I said, I'm gonna flip through it pretty fast because it's we've already gone over this ground here. We did a slide. This is calculation of damages. You can freeze it if you want. I'm going to go over it pretty fast. We'll break it down into steps. You calculate the total rent due under the lease from the earlier of the date of the filing of the petition or the date when you repossess, you meaning the landlord, repossess the property or it was surrendered to you. So what's the total rent due? That's the first thing. Compute 15% of that total. And this is the rent approach, which some courts allow. So this is the rent approach, 15% of the total rent. Then determine the rent reserves for 1 year following the earlier of the date of the bankruptcy filing or surrender of the property. And 4, determine the rent reserve for 3 years following the earlier of the date of the bankruptcy filing or the date of the surrender of the property. Under the majority view, the courts will then limit the allowable rejection claim to the lower of the 15% amount from step 2 and the 3-year amount from step 4, unless the 15% amount from step 2 is less than the 1-year amount in step 3, in which case the claim is limited to the 1-year amount. I don't know if that helps or makes it worse. Calculation of damages under the time approach. Calculate the time remaining, not the rent remaining, multiplied by 15%. Damages are capped at the greater of 1 year's rent or the amount of rent due for the first 15% of the remaining time of the lease, such time period not to exceed 3 years. So you have a 3-year cap. Okay, we're going to switch gears and talk about another aspect of calculating breach of lease damages. This is the MDC case, Bankruptcy Eastern District of Pennsylvania. It's a recent case, 2013. And it illustrates an important part of this cap, and that is when the cap period begins and when it ends. And it can make a big difference in how much the claim amount is, how much the ultimate recovery is. Okay, so this is the fact pattern. MDC is the debtor that eventually files bankruptcy. Brandywine is leasing space. MDC allows another entity to occupy the space. Brandywine commences a default proceeding and gets a judgment and also ejects MDC for breaching the lease, ejects the debtor out of the space. So, of course, MDC files for bankruptcy, and the question is, well, what's the size of Brandywine's claim against the bankruptcy estate? Main question here is, how do we establish when the rent cap date should be calculated? In other words, the rent cap date is the date when the damages are capped. In other words, as a beginning date, as an ending date, and it's important for a number of reasons, and I'll go into that in a second. So this is the statute, 502b6. And the cap is applied to a certain period. And during that period, whatever the actual damages were, they're capped, so you don't get the actual damages. However, and this is very important, 502b6b allows any unpaid rent due under the lease before the cap date. So in other words, before the cap date begins, if you're owed money by the entity leasing this space, that's not capped. So you could be owed whatever money you're owed, doesn't matter, but that's not capped. So your claim against the bankruptcy estate can be the full amount of whatever you're owed up until the date of the start of the cap period. So what's the cap period? Let's go into that. Well, according to the statute, as we just saw, the cap period is supposed to begin on the earlier date of either when the case is filed, the bankruptcy petition is filed, or the date that the debtor last had occupancy of the leasehold. So why is this important? Who cares? Why is it important? Because if it's the earlier date, if it's the later date, for example, and it's the date of the petition, then anything up to that was owed on the lease, there's no cap on it. So it gets paid in full to the extent that the claim is allowed. There's no cap on anything before that. So the debtor always wants the earlier date. Why? Because it caps that. So in other words, the claim does not reflect the full amount of the breach during the cap period. So anything before, you get paid in full. Anything during the cap period, you get paid, it's capped. You get paid less. And so you want the cap period to start later, and you want a larger period for the pre-rent cap period. So of course that's what happens in every case. Brandywine is arguing that the rent cap date should be July 23rd, the date of the bankruptcy petition. Anything before that should not be capped. And the debtor, of course, is arguing that the proper cap date is December 29th, the date the debtor handed the keys over and quit possession. And so this is argued all the time, and that's the issue that's presented in this case, and it's important to know that that's an issue. Well, this is part of the judge's opinion, and I just wanted to show it to you. And basically the judge is saying, hey, this is important because it's the earlier the cap period, the shorter the unpaid rent period, which is not capped. So obviously it's important to both parties. And the court has got to determine, okay, when did the surrender take place of these premises? And he's got to look at state law. This is an issue of state law, not bankruptcy law. It's an issue of how state law determines this issue. And so the court looks at Pennsylvania real estate law, and he does his analysis. The end result, not that surprising in this case, is that the court determined that the cap date should start when the debtor handed the keys to Brandywine, according to the statute. So that's when the rent cap cap date started in this case. And but the takeaway is, recognizing that that's an issue and maybe pre-planning for this kind of an issue. Another important issue that the court goes over is that for you to get a claim against the estate, and for this formula and statute and part of the bankruptcy code to apply, you have to have a lease that's unexpired. And so the debtor argued here, hey, lease was expired, lease was terminated, and by the ejection action. And the court disagreed. It said, look, that was an ejection action against a third party, and the lease was still viable. It was still an ongoing, unexpired lease, so that the landlord was entitled to the damages as set forth in the statute. Another interesting issue is there's an obligation for the landlord to try to mitigate damages by reletting the space, and any costs relating to that are not going to be allowed as part of the 502b6 claim. They're not going to be allowed as a claim at all. And the court is addressing this issue as well. So that's sort of an ancillary issue. It's good to be aware of. You're not going to be compensated for that as a landlord. It's not going to be part of an allowed claim. And this is the part of the opinion where the court goes into that and quotes Collier, which is a standard treatise on bankruptcy. And it's just part of the opinion where the court says, hey, you're not going to get paid for that. You're not going to get any costs incurred in reletting the premises. Another ancillary issue, Brandywine wanted to include not an uncapped claim for the attorney's fees and costs that it had incurred in pursuing the state court judgment. And it's interesting that the court did allow that. So you get an entirely separate uncapped claim because it has nothing to do with rent. It's not rent, and theoretically, it's not really related to the lease obligation. So that's something to be aware of in drafting the proof of claim as well. So there were a number of issues in this case, a number of takeaways, and just to recap a little bit, the date that is used to start the cap period is the date of the bankruptcy or the date the property was repossessed, surrendered. That's in quotes because it's an issue of state law, whatever state law determines that to mean. And it's the earlier date, which I think I just said, between the bankruptcy, the day of the bankruptcy petition, or when the lessor repossessed or the lessee surrendered. So that's the cap date, start date. Anything before the cap date is not capped. So that's number two. Number three, if you have a claim for damages as a landlord, you have an obligation to attempt to relet the premises, resulting rents are deducted from your claim, and you don't get compensated for the costs of the reletting process. Well, here's another issue. What about deferred maintenance expenses? In other words, if you're a landlord, you're leasing out space, and the tenant is breaching his agreement to properly maintain the place, trashes the place, doesn't maintain it, and then files for bankruptcy. So the interesting question here is, so this is so-called deferred maintenance. I know I can say this. This is a so-called deferred maintenance claim. And this is a common issue also that's come up in a lot of cases. So is this deferred maintenance claim that should have been paid prior to the bankruptcy filing or prior to the ejection of the debtor from the premises. Should have been paid, but wasn't paid. So you can certainly make the argument that this should come before the start of the cap period as money that was owed up until the point of the ejection or the bankruptcy. And the other side of the argument is, since it wasn't paid, it wasn't part of the unpaid rent, and it's part of the breach of lease calculation that should be paid after the beginning of the cap period, and therefore it should be capped. So the whole issue is, should it be capped or not? And let's take a look. This is a New Jersey case. An important issue, involves can involve considerable money. New Jersey case 2000. This started out in the bankruptcy court level, and this opinion is issued by a district court level, so it's a little bit higher than the bankruptcy court, but not the highest level, which would be the Court of Appeals. I guess the highest level would be the U.S. Supreme Court, but we rarely get up to the Supremes. Okay, so a little name confusion. Let's just say the debtor is NV, and CPA is the landlord. NV rejected unexpired leases, and NV obviously filed for bankruptcy and then rejected the leases. CPA filed a claim for damages pursuant to the statute, and a dispute arose about the size of the claim. Okay, so the claim had the proof of claim. If you don't know, that's a document, usually a one-page document with exhibits setting out your claim against the estate. So a CPA filed one of these things and had three parts to it. CPA broke down the claim to three parts. The first is unpaid rent obligations. Those are paid in full. In other words, those are not capped. When I say paid in full, it's the full amount that you can put on your proof of claim, that you can apply to get paid. You're not necessarily going to get paid in full, obviously. It's just an unsecured claim. You're going to get paid whatever percentage they're paying unsecureds, but it's not capped, just to be absolutely clear about that. And then number two, a claim for unpaid obligations pursuant to the lease, that are part of the breach of the lease claim. And a claim for NV's breach of the lease requiring NV to maintain the properties in good condition, the deferred maintenance claim, and that's the main subject of this opinion. So the issue here is, do the deferred maintenance claims, the obligation to keep the property in good repair, is that part of the unpaid rent section, which is full, not paid in full, but set forth on the proof of claim in full, or is it capped? Also, the issue that we saw before in determining the amount that's owed to the landlord under the cap calculation. Do we use time remaining on the lease, or do we use rent due under the lease? And I think in a prior case, the court came down on the side of using time left over, and we'll see what happens in this case. It's a disputed issue among the courts. Courts differ. Oh, this is the statute. This is the relevant part of the statute. These are the arguments. Well, this is part of the opinion, and the court affirmed the bankruptcy court and decided that using rent as a percentage is fairer. And the court gave an example, and it's worth going into a little bit so you understand the rationale. And it's not hard to understand. So let's say a debtor rejects a lease with 10 years remaining under the lease. And in the first 5 years, the rent is $80K. In the second 5 years, the rent is $120K. So the whole rent, if you calculate the total that's owed over the remaining 10 years. It's $1 million. So if you take 15% of what's left over, of what's remaining, which is $1 million, then it's going to be 150K in damages. However, if you just use time and you take 15% of the 10 years, that would be 1.5 years, and you'd be using the earlier um, rent lease term of 80K a year, and it's going to be only 120K. And the court's basically saying, it's not fair and it's arbitrary to leave out the higher paying years. Or the court pointed out you may have a situation where the higher rent is in the first 5 years, and in the next 5 years is lower rent. So it's arbitrary and unfair. It's more consistent and fairer to both parties in different situations, in all situations, to use total rent and take 15% of the total rent, since the rent's going to vary from year, or may vary from year to year. So that's the summary. And this is, by the way, the majority view. So most courts are going to take this point of view. And it's important to understand what's going on and the basis for the calculation. The court then looked at the issue of whether deferred maintenance payments should be considered to be part of the unpaid rent period, which is can be applied for in full on the proof of claim, or whether these payments are capped, part of the cap calculation, which is obviously worse for the landlord. And basically, the court agreed with the bankruptcy court. The bankruptcy court looked at the legislative history, looked at pre-code cases, and basically came to the conclusion that the intention of Congress is that these payments should be capped as well and should fall under the cap. And so the court acknowledged that there's a disagreement among the courts, but this court decided that deferred payments, maintenance payments, should be capped and part of the cap calculation. Already discussed this when we directly looked at the opinion, and the court is holding that the rent approach is the better approach, and this is at the district court level. Again, different jurisdictions have different opinions. This is what this jurisdiction says. If you're in a different jurisdiction, the law might be different. That's what happens when the court splits. That's the conclusion. Deferred maintenance payments fell within the statutory cap, and we're going to be using the rent approach. Okay, and we hit a case here, which is bankruptcy court level in Michigan, 2012, that took the opposite point of view. So here, the court's taking a look at a very similar issue of deferred maintenance obligations and other forms of breach of the lease. And the question is, again, how do you interpret this statute? Are those components, those claims of the landlord, is that part of the breach of the lease that's capped in the cap calculation, or is that an entirely separate claim that shouldn't be capped at all? It's just an unsecured claim for damages, and the court addressed that issue. Fact pattern is the same as always. Debtor entered into a lease pre-petition. Here, post-petition, they remained on the premises, and they ended up rejecting the lease under the bankruptcy code, gave back the property, and the landlord filed a proof of claim for that had a couple of different sections in it. One was for the breach of the lease and rent, the rent damage part calculated under the formula provided by 502, and they had an additional claim in the proof of claim that was not capped, and according to the landlord should not have been a part of the formula, the capping formula. because that claim involved equipment they had to remove and damages and that kind of thing. So that, according to the landlord, Pegasus, this is an entirely different claim. So the issue is, should the additional damage claim be capped by 502b6, or is this really not appropriate and nothing to do with 502b6? Again, same statute, same arguments, and the trustee argued, of course, that that should have been part of a claim of a lessor for damages resulting from the termination within the meaning of 502. So what does that mean? It's vague. Are the damages, are these part of those damages resulting from termination of the lease, or are we just going to limit that to damages in the form of unpaid rent? Pegasus, of course, takes the opposite point of view. Additional damages are completely separate. An interesting argument the landlord makes is that if the lease had been assumed under Section 365, under 365, the debtor can so-called assume a lease, and basically the debtor has to cure all defaults under the lease, rents or otherwise. And Pegasus is saying, look, if the debtor assumed the lease, would it have to pay these damages or not? If it would have to pay damages for deferred maintenance, then it should be a separate claim and not capped. And the Pegasus is not pulling this out of the air. Those are arguments that have been made in prior cases, and some judges have followed that reasoning. Well, the court wrote a very extensive opinion on this issue and basically said, well, the first thing the court observed is the obvious. There's a split in the case law, and regarding the meaning of that phrase in the statute, quote, damages resulting from the termination of a lease, close quote. What does that mean? The broader view includes, in that definition of damages, includes obligations to maintain and repair, damages caused by the debtor during the lease, and that kind of thing. The narrower view of some judges is that no, that section only refers to rent. And so the question is, what view is the court going to follow? And the court agrees with Pegasus, the landlord, and decided that a narrower application of 502b6 is appropriate. And it goes into why. Basically, the rationale is that, yes, Congress intended to limit the claim of landlords for breach of lease and unpaid future rent payments. Why? Because if Congress didn't limit it, landlords would be dominating the bankruptcy case with these huge unsecured claims. So Congress didn't want that to happen. It wanted other trade creditors and other unsecured creditors to have a chance at getting some kind of a payment. So that's why they limited. But according to the court, it wasn't the intention of Congress to limit damage claims because that would hurt landlords too much. And that was not the intent of Congress. That would be swinging the pendulum too far in favor of other unsecured creditors by denying landlords valid claims that they have for damages to their premises and other claims. So that was the court's rationale and conclusion. So the test that the court followed, I think it's important to understand, and an important argument for landlords, and that is, if the debtor, hypothetically, if the debtor had decided to assume the lease, would this claim still have existed? and have to be dealt with as an unsecured claim, even if the debtor got caught up and cured the arrearages on the lease. Would this claim still have existed? If the claim would have existed, then it's a separate claim and it's not subject to the cap. And that's the line of cases and the rationale and the test followed in this by this particular judge. Well, this is yet another case to deal with the collateral damages issue and whether that should be capped. The difference here is that it's the Court of Appeals level. It's the Ninth Circuit. And it's also a fairly recent case, 2007. So this is the final answer in this circuit, unless the circuit changes its mind or unless the U.S. Supreme Court reverses the circuit, which hasn't happened. So what did they say? So here, typical fact pattern: debtor enters into a lease pre-petition, goes bankrupt, has an unexpired lease, and at some point rejects the lease. Landlord files a claim stemming from not only the lost rents, which are capped, but also tort claims for waste, nuisance, trespass, wet clay goo, mining equipment. This was not a happy landlord. This essentially, Your Honor, they trashed the facility. They trashed our property, and we want a separate claim. So the debtor, so the proof of claim was filed, and the way these things, the way these cases get in front of the judge is that there's an objection filed to the claim, and of course the debtor is saying, "Hey, this is all capped. This is all part of the cap. Don't waste our time with your additional damages. Stop being a crybaby." So let's see what the judge says. Well, first we got to know what the issue is. So that's the issue. They trashed the place, but should that be capped as well as the rent claim? Our beloved statute, I'm sure you're sick of seeing. And the arguments. Okay, so what's interesting here is that the bankruptcy court held in favor of the landlord, that the tort claims were not subject to the cap. Very sympathetic bankruptcy court to the landlord. Then on appeal, the bankruptcy appellate panel reversed the bankruptcy court's decision and found that no, this is all part of the cap. So a lot of controversy here in the Ninth Circuit, and it's appealed to the Court of Appeals. A lot of drama here. Anyway, so the Ninth Circuit looks at this and says, no, we're not going to allow this to be capped. This has nothing to do with the rent claims. And the court uses some colorful language. The million ton heap of dirt that was left was not put there by the rejection of the lease. It was put there by the actions and inactions of the debtor. And part of the rationale of the Court of Appeals is that, look, if we're going to cap damages, we're going to encourage debtors to walk away from these things. We're going to encourage, debtors are going to say, hey, we can do whatever we want. We can destroy this place, and our damages are going to be capped. So why, it's encouraging debtors to trash, to break agreements, to breach leases, not only in rent, but to do whatever the heck they want, and then just walk away and reject the lease. So we don't want to encourage that kind of behavior by corporate America, and so we're not going to cap the damages, so that next time these debtors are going to think twice before trashing the properties of innocent landlords. So I just showed you the opinion itself, and this is our summary of the opinion, and basically it says the exact same thing. I'm going to flip through. You can always pause the video if you want. The Ninth Circuit followed the test that we saw in the last case. If the lease was going to be, if the debtor had assumed the lease, it needed to cure all defaults. So would the curing of defaults apply to the rent, and would this claim for these claims based in tort uh, and waste and nuisance, breach of contract, would these be part of that assumption, or would this be a separate claim against the estate? And if it would have been a separate claim, then it should not be capped by 502b6. And here the court found, yes, it would have been a separate claim. So it would still have a claim. So in other words, even if the debtor got caught up on all the rent, would this claim exist? Yes, it would clearly exist, according to this Ninth Circuit Court of Appeals. And so it cannot be capped. Okay, this is our nice conclusion that we wrap up this case with, but it only applies to the Ninth Circuit. Okay, let's switch gears. This is a different issue now. So in this situation, you have a steakhouse goes bankrupt and rejects the lease during the bankruptcy, and the landlord sells the building right after the rejection of the lease. And the question is, does the landlord still have a claim for future lease payments under 502b6, or did the sale of the property terminate the claim? Does it have an impact on the claim that the landlord can now file since the property has been sold, and the argument is no further rent would have been due since the property's gone. So that's the issue. Well, that's that's a slide of the issue. Really the same statute. Well, the uh, the arguments were interesting. The debtor argued that the landlord mitigated its damages by selling the property and indicated an abandonment of any indication that the steakhouse was going to continue its lease, and so it's not entitled to a claim for future rents. The landlord argued, no, under Minnesota law, we're not required to mitigate. There's nothing to do with it. The sale should not result in any kind of reduction. And again, the court has to apply Minnesota law for this issue. Was there on the implications of the sale, and whether this resulted in a abandonment or mitigation, and what impact it had. It's a state law issue. Well, the court agreed that there was no duty to mitigate, but by selling the property, this basically constituted a forgiveness of the debtor's further obligations under the lease. So the court's basically saying, you're not going to get a windfall. You're not going to get paid twice. You sold the building. That's your compensation and mitigation, and we're going to disallow your claim to the extent that it includes damages after the sale of the property. So that was the case here. That's limited to this particular judge and Minnesota state law. So the results may differ in your case. That's the conclusion. That that's our wrapping a ribbon around this case. But again, results may differ. This is another Court of Appeals case in the Ninth Circuit. And it reverses a lower court decision. It just shows how confusing this law is, since there already was Ninth Circuit precedent, and the lower courts apparently still got it wrong. Statute. And the issue is the same we've been dealing with. does addition, what's capped and what's not capped. If there are damage claims or attorney fee claims that are relating to tort claims or other issues that are not related to rent claims, and that part of the breach of the lease, then should those be capped or should those not be capped? Here, what happened was there was an arbitration award, there were attorney's fees um, relating to ancillary issues, and there were also attorney's fees relating to uh, payment of future rent. And so, which are capped, which aren't capped. That's the problem. The problem that the Court of Appeals had with the lower court is that the bankruptcy court and the district court affirmed. The bankruptcy court just decided that any attorney's fees and any arbitration fees, none of them should be part of the cap. Um, and some of the attorney's fees related to future rent, and so the Court of Appeals had an issue with that. That's a summary of the issue, arguments. Basically, the Court of Appeals said, "Hey, you got to be careful about categorizing this stuff." And the way to look at it, according to the Court of Appeals, is again the same rationale. If if the lease had been assumed, um, what damages would be paid, and what damages, uh, I retract that. What damages would form a separate claim, and what damages would not. And the Court of Appeals said, hey, if the lease was assumed, then damages with respect to future rent are not going to be a separate claim because the lease is being assumed. The lease is being cured. All past rent is being paid, and a commitment is being made under bankruptcy court order to pay all future rent. So that's not going to be a claim. Attorney's fees relating to future rent. However, claims for past damages unrelated to rent are going to be a separate claim, even if the lease is assumed. And so what the bankruptcy court did, and the district court affirmed, was basically, did a black and white decision. Any attorney's fees, arbitration award, that's not going to be subject to the cap. And the Court of Appeals said, no, you can't do that. You got to categorize carefully uh, which ones uh, are going to be capped and not, which ones relate to future rent. So, the conclusion, it's obviously not an easy task, um, but since there already was a Court of Appeals decision here, and it's still difficult to figure out, and so the answer is um, uh, you have to take a look at is the landlord damages directly resulting from lease termination, or is it really an independent claim resulting from another form of damages?